Good afternoon, everyone, and a very warm welcome to you for attending our online forum and our online customer council. This is a private forum by invite only, so we're really grateful that you're here today, guys. Thanks so much for joining us. I'm really pleased to be joined by Lucas Stirrup, who is Employment and Labour Law Partner at Lexons, which is one of the Netherlands' leading law firms. They're ranked in the Chambers Legal Guide as highly rated and top ranked, and also in Legal 500. So Lucas, a warm welcome to you, a warm welcome to our guests today. We're really excited to unpack some of the challenges around what's coming up in the Netherlands from a legal and regulatory perspective. We're going to be looking at the potential impact from a business perspective, some of the changes that are coming. We're going to give you really a 3-year window into some of these changes, because some will take effect in 2026, some will take effect in 2027, and some will take effect in 2028 is the intention behind that. We're hoping to have around 45 minutes or so just to go through some questions that we've prepared with Lucas. And also we'll save some time for the end for some discussion. So I'm going to keep this brief on me. I'm the host for today. My name's Conor Heaney. I'm the president at CXC Global EMEA. Don't need to read all this stuff. Most of you know me already, and if you don't, we'll send the deck after. So thanks again for joining us. As I mentioned, we're really pleased to be joined by Lucas Stirrup. I've had the pleasure in CXC of working with Lucas for the last 6 years on a whole host of employment and labour related matters. And Lucas is really at the top of his game when it comes to employment and labour law in the Netherlands. So Lucas, I know our audience are excited. I'm excited by what we're going to talk about today, and we're really going to get into some of the specifics. Just some housekeeping, guys. So really pleased that you're here. Mentioned that a number of times. Thanks again for your support and interest in this topic. We've had some questions come in already, so thank you very much, Carrie Cottle, for your question, and we welcome questions throughout. So Pete Botto from our marketing team will be looking at the chat just to see what's coming through. We are recording today's session. We're also using an AI assistant, and that's to help us with some of the follow-ups around notes and briefing documents. Please take notes though throughout. Questions are most welcome. Any fun facts, please put them in the chat. And of course, enjoy the session. So just to reiterate as well, guys, this is a closed forum. Be vulnerable, ask the questions. If you're really unsure about something, just put up your hand and we'd love to hear from you. And hopefully Lucas or myself can answer your questions, and most likely Lucas. So just before we begin, I think it's fair to say that the Netherlands has traditionally been one of the most flexible labour markets in Europe. It has a long history and tradition of freelancing, temporary agency workers, and independent work as well. But since really 2017, much more legislation and regulation has come to bear. We've seen the DBA, or the WED Act, come into place in 2017. When I first started working with Lucas back in 2019, the WAB legislation and regulations were coming into effect in terms of how temporary agencies were governed, and also how temporary agency work was performed. Lucas did a really good job actually of guiding us through that, and our clients as well. So thanks again, Lucas, for that. But I think it's reasonable to say that the Netherlands market from a staffing, employment, labour law perspective is going to become much more complex. It's going to lose a lot of the flexibility that has been traditionally associated with the Netherlands. And as I mentioned already, we're going to see really a 3-year horizon about what's going on in that particular market, and how potentially your organisation, your team need to prepare for that. So with that, Lucas, what is coming down the tracks? What do we need to be aware of from a labour and employment law perspective from 2026 onwards?
Yeah, thanks, Conor, for the great introduction. Well, there definitely are a few things coming your way. In part, these are based on European legislative developments, but also the debate in the Netherlands about certain areas of the job market. I think for today we have a couple of topics. One which has also my very personal interest due to being involved in in landmark case of the matter is the V-bar bill that is coming into force, which basically aims to provide more clarity on how working relationships are to be assessed. Basically, the discussion is someone, an employee or an actual independent contractor, a freelancer or not. And then there's also I'll use the Dutch words, more zekerheid, Flexwerks Act, basically an act aimed at strengthening the certainty for employees with flexible contracts, and particularly regarding income and working hours, but also it's aimed at reducing the differences between permanent contracts and flexible employment contracts. Then, and this is particularly relevant for temp agencies, there will be a new law coming into force, basically replacing the existing WADI, which is a law that governs basically let's say the secondment of workers and the conditions under which they can be seconded. This will entail that these temp agencies, as of January 1st, 2028, will have to have a license, and without that license, you cannot, work as a temp agency anymore. Then, from the European side, we have the Equal Pay Directive coming into play, and I think this is also something companies should really start to take mind of, to identify risks and to adapt before it will be implemented in local legislation. And then I think finally we have the Platform Directive, which aims to ensuring that employment status of workers that work via this platform, such as a Deliveroo, for example, are qualified correctly as an employee or independent contractor. And there's also this requirement of transparency. You have to show how the platform works, how the algorithm works, to ensure fairness and accountability. So there's quite a lot of changes coming your way, and some of these will have a significant impact, especially if you make use, of course, of flexible workforce type of workers in your organization.
Thank you, Lucas. I think that was a really good summary of what's coming down the tracks. I think it's fair to summarize that we will see a tsunami of legislation in the Netherlands, and it's going to completely change how workers are engaged and managed. I think that's completely reasonable to say. Thanks for that overview, Lucas. So what I'd like to do now is really move into some specifics. Lucas, we're going to talk about the V-bar bill that you mentioned there in your introduction. So for some of our non-Dutch audience, many of you will be familiar with IR35 and how that was rolled out into the private and public sector over the last number of years in the UK. And that really relates, as most people will know on the call, to whether a worker should be treated as a independent contractor, either inside or outside IR35. And as we'll see, there's some similarities to IR35, but there's also a lot of things that are completely different and specific to the Netherlands. So, Lucas, with that, can you just walk through our audience the main items of the V-bar bill and how employment status is proposed to be checked or classified in the Netherlands?
Yeah, definitely will. Maybe also here it's good if you could pull up exactly. I will explain that. So the V-bar bill basically tries to codify, at least in part, existing case law on labor relationship assessment and clarifications. So it's aimed at indeed providing a legal framework for assessing whether or not a specific worker is employed as an employee, or if the criteria for independent contractor status have been met. So this overview that you see here is an actual decision tree that's also included in the legislative proposal itself. I'm not sure if it's readable for everybody here, but basically I will walk you through it. What it does, and this also explains what the aim of the act is. So there's several elements that need to be weighed, and ultimately, if you weigh all these elements, you come to the decision: is there an employment contract? or is there no employment contract? So it starts with the indications of being an employee, and these are largely focused on, you know, the supervisory authority and the control that the user or the would-be employer have over the employee. For example, does the worker get instructions? In what way are the work activities controlled by the end user? Does it have a structural character, or is it only incidental? So there's all these elements which have been derived from case law, which are deemed indicative of, you know, in the employee status. Then you move to the I on the screen, and this is basically these are the elements that are indicative within that specific relationship of independence, so actual freelancer independent status. There are such things as, you know, does the independent contractor have a real financial risk? Does he use his own tools? Does he have a specific expertise that's not available in the company that is making use of the worker? You know, the elements that clearly display that they are working independently. So then you have to weigh the outcome of these assessments, and then you come to the next step. And if the conclusion is that the indication for an employee outweigh indications of independence or the freelancer status, then you have an employment contract. If on or about these elements are equal, then you move to a new part of the assessment. And this has actually also been recently confirmed in a Supreme Court case between Uber and FNV. And basically you look at the entrepreneurial status of the worker outside of the relationship with the would-be employer here. So you look at things like, do you have multiple clients? Do you have your own process for acquisition for clients? Do you have a web number? And do you work independently outside outside the scope of the relationship that we're assessing here? And if then the conclusion is, yeah, there are significant indications of the worker being an actual entrepreneur, then it might move into the bracket no employment contract. But if these elements are not there, it could still be an employment contract. And of course, similarly, if the indications for independence outweigh the indications of employee, there is no employment contract. So, well, the goal is to create a simple and also a new framework for the assessment of, you know, the employment status. In reality, this is basically a codification of case law. So it is questionable whether or not this actually creates certainty and clarity. I think it will be quite a complicated task still to implement it, especially if you're making use of large numbers of freelancers, for example. So yeah, so it's an interesting change that's coming up, but I doubt if it will have the desired effect. But maybe we touch upon that subject later. But yeah,
Yes.
Does that help you understand the what's coming in this direction?
Yes, certainly, Lucas. As always, Lucas, I've got a few questions, so I hope you'll indulge me on our audience. So the first question, Lucas, is who is responsible for undertaking this assessment or classification? So let's say, for example, Big Bank A in the Netherlands, they've got thousands or 100 plus contractors, independent contractors. Who is responsible for undertaking this assessment? Is it the end user or the intermediary, let's say a staffing agency or a payroll company? How does that work based on the codification?
Yeah, well, so the law doesn't really zoom into that specific question, but ultimately I think you look at where does who bears the risks, right? So in that sense, I would say that definitely also the end users should be very aware that this could pose risks, because if a worker is classified as an employee, that triggers, well, a lot of other stuff which we'll also touch upon after this. But so and also the intermediary, depending on how the intermediary structures the secondment or the making available of the worker could also be liable. So, and ultimately also the individuals should also take mind that there could also be consequences for them, negative financial consequences if they work for several years on the assumption that there would be an independent contractor, but afterwards it's determined that they're not. But so definitely the end user should take very good note of this upcoming legislation, because it will potentially create significant risks, also depending on how well it's going to be enforced.
I think the enforcement point is a really good one, Lucas, particularly if we look at the DBA regime around model agreements. Essentially, for many years, there was a light touch or no regulation there around that, right? And the tax authorities really just let things go from that perspective. But I think that's a fair question. Will it actually be enforced? But I had a question, Lucas, and I'm sure our audience are thinking this too, or elements of it is when the UK government brought in IR35, they also brought in an online tool that the UK tax authorities, HMRC, essentially produced and they manage it. And it is called the CEST tool, CEST tool. And as I recall, in the Netherlands tax authorities or the government authorities essentially piloted a similar tool in 2023 and 2024. Can you tell our audience, Lucas, will that tool be available to help organizations or end users classify these workers correctly?
Yeah, so I think there's a web module in place that helps you determine indeed the outcome of the assessment. I do not think, however, that it has been updated on the basis of the latest changes in the legislative proposal, which has also been impacted by recent case law of the Supreme Court. I would expect that there will be a similar web module available, and otherwise I think there will be let's say off-market, not government provided web modules. The difference and the danger, however, is that, and this is also one of the points of critique on this framework of assessment, that if you look at the individual indications that you need to weigh to come to a certain conclusion, these are often quite subjective, and you might also need legal expertise to correctly validate or weigh such elements. So there's always also a risk involved in using such decision trees. That's although it might seem as an easy good thing to use such a web module, always be mindful that it could also easily move you in the wrong direction. But I think there's not yet an updated version of it, but I would expect there to be one. Also depending, of course, on the new Dutch government and the direction they will take, because outside of all the legal development, that's always a factor that you also need to account for.
Yeah, I agree with your note of caution there as to whether this will be fully implemented. A couple of things that I find interesting, and maybe our audience will too, Lucas, is around the law of unintended consequences. So when the Dutch tax authorities essentially said, we will start to enforce the model agreement regime, I was looking at some statistics for Q4 2023 and Q1 2024 in the Netherlands. And by my crude estimation, Lucas, it looked like new freelancer or independent contractor registrations plummeted. It looked like they reduced by roughly 40% when compared to the previous figures year on year and the previous figures year on year before that. And I suppose my question really is, Lucas, what do you see as the unintended consequences of this legislation? What do you see as the potential impact or risk around it?
Yeah, so it's also funny that you mentioned the enforcement of by the tax authorities of the wet DBA. This is also really shows how the market responds to these kinds of changes. So the underlying assessment framework in its even in its current form has not really like materially changed over the years. It's just how it's being applied and how the tax authorities and the market deals with it. But also the WDBA, but also the VBAR in development have an impact on how the market responds. But if the tax authorities say we're going to fully enforce, this whole assessment framework, you see that that commitment by the tax authorities has a bigger impact than the legislative proposals themselves, right? So I think the market looks at this from a risk perspective. So if this comes into force, I think initially what you also saw when the tax authorities started enforcing this, initially there will be a drop potentially in the hiring of independent contractor freelancers, because the market will want to look what will be the factual impact of this new legislation. And I think there afterwards, there will be some consolidation. So yeah, I think realistically the impact of this particular set of regulation will not create a real material change, because it's basically a codification of existing legislation. It will still depend on the individuals claiming, going to court and claiming that they're an employee instead of an independent contractor. Now, what might really impact the market is if the tax authorities start aggressively using this, and this creates a certain awareness and a certain momentum where the market thinks, okay, now we have to be really, really careful. So it will depend on a variety of factors, but in itself, I would say it doesn't create big shock waves. It's the additional circumstances that will, provide an answer to your question.
Yeah, I understand, Lucas. And Lucas, I did have a question specifically on the VBAR legislation or regulation. So if I compare and contrast it to IR35 in the UK, with the IR35 legislation in the UK, there was a defined sanctions or penalty regime for organizations that got it wrong, essentially the end user. So there was really three grades around that, or three circumstances, and depending on the severity of the offence, then the fine was higher. My question is, with the VBAR draft legislation, is there any penalties or sanction for the end user companies within that legislation?
Not within the legislation itself. I mean, from a tax perspective, if you fail to comply with correctly applying, whether or not it's an employee or a worker or independent contractor, and therefore if you fail to pay the correct taxes, there might be penalties due. But what this tries to do is not so much create penalties or provide the tax authorities with means to enforce the system. It's basically meant as to provide clarity of the underlying framework. So generally speaking, there's two risks involved for the end users and also for the workers themselves or the intermediates. First is that the worker would claim, I'm actually not a freelancer, but I am an employee. And the worker will have to go to court to get a verdict on that. So that verdict could also apply to a larger group, as we know from the case law in the Netherlands. So there's the risk is not so much a penalty, but it's the retroactive effect of that decision. Imagine holiday pay, vacation hours over years, maybe with salary corrections, you name it, sick pay benefits that haven't been paid during periods of sickness, absence. So it is a very big risk in that sense, but it depends on the individual workers or maybe the trade unions, as we also see, going to court to get that arrangement or the contract reclassified as a employment relationship. And on the other hand, the second risk is the tax risk. And there, of course, penalties come into play. And there has been a regime where if you could honestly say, oh, I did my best, but still, okay, I got it wrong, then they were lenient. So it will also depend on how they will deal with it in the future, how big that risk will be. But again, there's also a retroactive risk about paying social premiums, wage taxes. So on both sides of the fence in that sense. The risk can be significant even without penalties and such.
Well, I think it's going to be really interesting how this plays out. I know I'm failing the SWOT test here for our audience. I think, Lucas, I'll give you a break from speaking. What I should have mentioned as well, folks, at the outset of today's forum, is that whilst Lucas is one of the leading employment and labour law lawyers in Netherlands, the purpose of today's session should not be taken as any binding legal advice. Lucas is merely here in his capacity to give his opinion on the legislation that's coming through. So in short, don't act as if this is advice, but merely guidance from Lucas. So that's our disclaimer that I should have mentioned at the start. So Pete, hopefully that keeps our well, actually Mandy, our legal counsel's here. That's good. So we're all in the good place here. Okay, Lucas. So just want to move on, if we can, from the independent contractor freelancer world to the VAB or WAB legislation that came into force on January the 1st, 2020, as I recall, and I hope that that recollection is correct. In the temporary agency space and in relation to temporary agency workers, there's going to be a change, Lucas, is that fair to say? And the change relates to the break that temporary agency workers could previously take, is that correct? And would you mind just explaining to our audience what the change is and what it's going to look like?
Yeah, so there's a couple of changes that fall in this category, and also that are going to be codified or implemented through the more, I translate it as the More Security for Flex Workers Act. The chain rule reset is one of those elements. To start there, which also falls within in this category, there has been a Supreme Court judgment end of last year, which clarified what should be understood as remuneration in terms of the equal remuneration obligation that applies for posted workers. So temp agency workers that have been posted at the end user client. We used to think that there's only a set number of employment conditions that would be weighed and should be applied. But actually, the definition of remuneration is much more broad. And it basically encompasses all employment conditions that the employees of the end user have. So that is a Supreme Court judgment which also will be incorporated in this act, and this will already be in effect also as of the 1st of January 2026, and also included in the temp agency collective labor agreements. Another part indeed of this set of rules that are aimed at providing that security for flex workers is indeed the extension of the so-called chain rule. So what does this mean? You have consecutive employment contracts, and normally you're only allowed to have 3 definite term employment contracts, or after 3 years of multiple employment contracts, it will become a permanent employment contract. So the employment contracts that would follow each other within a period of 6 months would normally be counted for this rule. So yeah, I think that was pretty long already. It used to be three months, but now it's 5 years. So that's quite a big change there. So if you have 3 employment agreements, consecutive employment agreements, first maybe on this date, and then 4 years from now another one, 8 years from now another one, and 11 years from now also another one, you will be faced with the fact that you need to have a very good administration and back office to look at the fact that you might suddenly have a permanent employee. So it really makes it difficult, and this is the aim for companies to, what is negatively associated with the revolving door method, where you hire employees, then you wait for 6 months, and then you can rehire them again. So that will basically become impossible, because 5 years, that's not a realistic period, of course, anymore to apply that principle. And then there's also the abolition of 0-hour contracts. So the on-call workers. Not sure if is this also included in this slide, or otherwise I'll keep that for the next. But
thanks, Lucas. So Lucas, that's really helpful. I think one of the points I made at the outset around the labour market being really flexible in the Netherlands, I think that just demonstrates how inflexible it's about to become. So it's really fascinating what you were speaking about. I'm just going to break, Lucas, for a couple of questions that have come in from our audience. So I've got first question, Lucas, if I may, comes from Mandy Bala, who is our internal legal counsel for EMEA. The question is, will the government issue new standard templates or new standard model agreements once the fee bar is enacted? Is that correct, Mandy? Was that the substance of the question? Mandy's
That's
not
right.
here.
Thank you.
Thank you.
Yep.
Thank you.
Conor.
No, so yeah, these model agreements that were issued by the tax authorities, indeed, in relation to the act, the DBA. The current ones, I think they are set to expire, so I don't think that as a consequence of the VBAR, there will be new model agreements now. Yeah, as far as I know, no. But ultimately, you could expect that such agreements maybe could be provided for again if amended to fit basically the decision tree that I just showed you before. It could be that there are, but I'm not aware of any plans to do so, because also the current ones are set to expire at some point. So that's the current status.
Okay. Makes sense. Thanks, Lucas. Lucas, I've also got a question here from Carrie Cottle from CSL Baron. Thanks, Carrie, for joining us, and thanks for the question in advance. The question relates to the following, Lucas. Are there any differences regarding and this is going back to the independent contractor stroke freelancer points that we talked about earlier in relation to fee bar. But the question is the following. Are there any differences regarding the potential impact of the changes if the worker is operating as a sole trader, stroke ZZPer, or if they're operating through a BV structure, which in short is a limited liability company for our international non-Netherlands audience? Is there any difference?
Yeah, that's a great question, and also it ties into the reality of the market, especially in some certain areas of freelance work, where freelancers do in fact have a limited liability company or BV in the Netherlands themselves. So it will impact the assessment somewhat. And if you would cycle back to the overview that we have in the decision tree, you will see that the elements that are indicative of entrepreneurship, so the EP on the screen, could potentially influence the total assessment. And now having a BV, a book, an accountant, and operating it as an actual business could provide some weight to the argument an actual entrepreneur. But ultimately, also what we see, especially the tax authorities doing, they just pierce through the legal structure and they look at the facts. So even if you have, so this is ultimately, I think, the answer. Even ultimately, if you have a BV in between, doesn't take away the risk. It might help you in the explanation, and it also, at least superficially, allows you to match your argument to an actual entrepreneur. But ultimately, they will look at all these circumstances here to determine whether or not it's an actual independent contractor status or not. And this is also with respect to a lot of the managers in the Netherlands working with management BVs constructions. They will still, in principle, be tested on the basis of this assessment schedule. And especially the tax authorities will pierce through the BV and decide whether or not it's a worker or, independent contractor status or employee.
Thank you, Lucas. And Carrie, thanks for the question, and likewise, Mandy. So, Lucas, moving on to the licensing regime change. So I think that this forum today is quite prescient. So for those of you who follow staffing industry analysts, they had a part of their newsletter today around the proposed changes that are coming into play. So as I mentioned earlier, guys, we're trying to give you a 3-year horizon or forward view into the legislative changes, 2026, 2027, 2028. But Lucas, just for the benefit of our audience, can you explain just some brief background on the current licensing regime through the FADI or the WADI, depending on your pronunciation, and the proposed WTTA change and what that licensing regime is going to look like for temporary agency suppliers or recruitment suppliers.
So currently under the existing Workers Allocation by Intermediaries Act, or the WADI, as a temp agency, as a lender, you have to register as such with the Chamber of Commerce. And additionally, there are some possibilities to get certain certifications, NEN certifications that indicate that you are compliant with the underlying legal framework, but that's not an obligation. But now external parties can check whether that NEN certification is in place, and then that provides you with some certainty of the quality of basically the temp agency and their compliance ultimately overall with the legal framework. Well, the WADI will be replaced with the WTTA in 2027, and the most important change there is that from now on, the temp agencies or the lenders, they will require a license to be able to operate as such. And yeah, so there's and within that license, all the quality assessments, the compliance assessments, also the financial position and such elements are a requirement, you know, for the lending agency or the temp agency to meet certain requirements for being allowed or being approved under the license regime. So if you don't have the license, you can no longer operate as a temp agency. That's the ultimate decision, and I think it will help in removing some of the, well, let's call it the rotten apples on the market. So it might be a good thing, but it's also the landscape becomes quite strict in that sense.
Yes, and I think there's a degree of harmonization across the European Union or Eurozone around this. Lucas, it's a very similar regime to Spain and Italy, where you have to put a labour bond essentially in place. I think the amount is quite low relative to Spain and Italy. I think it's around 100,000 euros for intermediaries or labour lenders or providers. But we're definitely seeing this convergence and this harmonization across Europe, and that leads us nicely, Lucas, on to the topic I wish to discuss next, which relates to pay transparency and gender pay reporting, because I've been traveling a lot across Europe this year, meeting our partners and other law firms and also some of our clients, and this has been a big topic of interest. So, Lucas, can you just explain for audience what's happening in the Netherlands and what are some of the timelines that we can expect around this?
Yeah, so I mean, this is all based on the Equal Pay Directive, on the European level, and you know the member states of the European Union will have to implement this. I think it was also by the 1st of January 2027, if I'm correct. So what it aims to do is to ensure, of course, that the pay gap between gender, so male, females, etc., are diminished, and also it forces employers to categorize between jobs and to give insight in potential gender pay gaps in that sense. And there's quite some how do you say consequences if you do not have your stuff in order as a company, I think, because people might think that this is, you know, we're pretty equal, we don't make any differences between gender in pay, but the system requires that you categorize certain roles. But it could well be that several roles are weighted the same, meaning that maybe historically, you know, for some other reason, certain positions could have been held more by males, and there's a higher salary attached, which isn't necessarily meant to be aimed at discrimination, but it's just like a fact. If the assessment shows that this discrepancy is there, you could be liable for the difference towards female employees, right? So it is a big change coming up, and I think companies would do well to really mind what's coming, because it will take a time to adapt the organization to be compliant with this upcoming legislation. So it's also good to understand that how this will work. Employees will have a right to information, so they can ask about the remuneration policies, and also to get some insights in the remuneration of different positions, and also the gender based differences. So if there's an indication of a difference, then it becomes the burden of the employer to actually demonstrate that this difference does not arise from a gender or discriminatory circumstances. And if you are not able to do that, then as I said, you are immediately liable for towards the employees that could claim compensation under it. So it's basically a reversal of the burden of proof once there is an indication of a difference. And it doesn't necessarily mean that the difference is based on gender, but if you're not able to objectively and adequately establish that the difference is based on something else, something which is like a reasonable, rational, and tied to the nature of the work, then yeah, as an employer, you have a big issue. So it is it could potentially have a really big impact on employers.
I agree, Lucas, and I think it's about just getting operationally ready is probably the key takeaway for that. Again, an obvious point.
I would say definitely it's really important to map and to start analyzing your pay structures in the company to identify potential issues here. So to be ready to make sure that those gaps are removed, because otherwise I think there will be a lot of work for the HR department and also as lawyers to discuss those situations afterwards.
Yeah, good for the lawyers, Lucas, and that's no bad thing, right? So, but Lucas, I did have a question in relation to this legislation or draft legislation. Will that be applicable to temporary agency workers under the proposed changes that are coming in? And also, does this apply to independent workers, contractors, or freelancers, or are they excluded from that directive or regulation?
Yeah, so it applies to employees primarily. So I mean, that's as far as I'm aware, there's no freelancers to be involved there currently. But yeah, it applies to all employees, and also remember that temp agency workers there's also an obligation to pay them the same salaries as the employees of the end user themselves. So this also ties into the gender pay situation, of course. So it will be an all-encompassing change there. So it will apply to the entire workforce, indeed.
Okay, thanks, Lucas. That's clear. Lucas, this is a topic that you and I have been speaking about for years now. I think since 2020, we were speaking about the EU directive on platform workers, which essentially is trying to right a wrong, depending on your viewpoint. But in short, it's basically giving gig workers that are engaged through platforms consistent rights, right? So the right to be treated fairly, the right to not be dictated to by an AI or an algorithm. And of course, there's a burden of proof to show, or at least there was a burden of proof to show that the worker is truly an independent worker and not an employee. But can you just give our audience a flavour for how the Netherlands is going to bring this EU directive into what's called national or local effect in the Netherlands, Lucas?
Yeah, so well, the directive is aimed, like the VBAR, is aimed at ensuring that the employment status is correctly determined, right? So either you're an employee or you're an independent contractor. That's still the underlying question of the directive. And secondly, it's aimed at promoting fairness and transparency of the algorithm and how it works. So what the initial proposal did was indeed create a framework, and if you meet a certain criteria, then the burden of proof would flip, and you would have to demonstrate as the end user of the company, employer, that in fact, these were not employees, and if you were not able to do so, then automatically they were employees and they would have the attached rights. So that has been changed somewhat. So now this has been moved or left over to the national states to implement in accordance with their own legal system and case law and CLAs and everything. So immediately, if you think back a little bit, what the idea was to create like a uniform situation in Europe, right, where like a certainty of how this would be applied. Immediately, you spot an issue there, because now you have this directive and it becomes a fragmented situation. Because even if you look at case law around the big platforms like Uber or Deliveroo, which we had in the Netherlands, also you see that national courts assess these matters differently, right? So this, presumably, if you start to implement this on a national level, there will also be different outcomes. So that's one big concern that I have. So what if the original purpose of this system will contribute as much as it initially would have had, at least in the view from the perspective of protection of the workers. In the Netherlands, there is not much information yet available on how this will be implemented, strangely enough, because the time is ticking, right? So I think the 2nd of December next year, that's the end date for implementation. But I think the Wet Weber gives us some insight and also on how this might be implemented, because that is also one of the critiques on the VBAR Act. It has been largely based on case law in the Netherlands revolving around platforms. So you can expect, I think, it to tie into the VBAR Act and how that would work in the Netherlands in a similar assessment frame, because otherwise it would be quite strange that for the general population of independent contractors, ZZP'ers or freelancers, you would have basically case law that has been codified for platform work and then a different methodology for platform work. So I think it would be something in that direction as well here. And of course, the additional part here is how will companies be forced to show insight in their algorithmic decision trees and how that affects certain decisions such as dismissal and things alike. So it's going to be an interesting development still, but I think will be closely tied to the VBAR Act.
Thanks, Lucas. Lucas, the reason I'm smiling is because that was just such an amazing analysis from you in terms of where this is potentially going to go. So really appreciate you sharing your experience and thoughts around that. So Lucas, we're coming up towards the end of today's forum. Just continuing to look ahead, I suppose I've really two questions before hopefully we can make some time for additional questions. But really, the questions are the following. What do you expect to be the compliance and administration burden for organizations, particularly end users, to implement the legislation, essentially to make sure that they're compliant? Do you expect that to be considerable? That's question one. And then question two is, do you expect this direction of travel where the labour market in the Netherlands is becoming much less flexible?
Yeah, so to start with your first question, yeah, I think indeed there's going to be quite a significant administrative burden on companies. If you only look at the way that the VBAR dictates how you would have to assess the status of workers. I mean, imagine you have like a couple of hundred freelance workers coming in on an annual basis. If the test basically assumes an individual assessment, right? So if you would fully follow that directive, that system, it will be a bizarre requirement for companies to apply. So what I expect companies to do is just to work in the safe zone and only where necessary go into in a deep dive and individual assessment there. But also, for example, the Equal Pay Directive, I think, will be quite burdensome to especially for larger organizations, to identify risk and to look at unforeseen consequences of the new legislation. So definitely, yes, I think at least for the coming years, I think employers would do well to be very mindful of all the changes coming and keep a close tab on these changes to ensure that they start in a timely manner to address these where possible. Where is the Dutch labor market going? I mean, definitely the vector here is moving towards more regulatory system, of course, which with a lot of complicating factors. So I think definitely less flexible for now. But at the same time, we also know that changes in government can also affect these vectors. So currently, yes, it's looking quite dire in the terms of it's going to be overly regulated potentially, especially from the perspective of do we want innovation? Do we want to compete on a global scale with the likes of China and such, right? So you can have a philosophical debate about that, but it's still a valid question how it will affect not only the Netherlands but also these developments in Europe, how it will affect the innovation and flexibility of the markets. So it's an interesting time to be an employment lawyer for sure. But yeah, I'm optimistic still because I think ultimately, the markets will require some flexibility, and it will be found and it will be there, but it just requires a little bit more thoughtful planning and assessment.
Yeah, I think that's a great way to close. Lucas, I think, I mean, the demographic side of thing is quite interesting, and if I can explain further, if we look at Western labor markets, the available labor in markets has been declining, particularly in the Eurozone. I think it's reduced over a 60-year period by 33%, right? So there's 33% less people available to do the work, right? So if you need the work done, I mean, where do you bring the people from, right? So, and I suppose if you've got a less flexible labor market and you've got increased rules and regulations around how you bring people into your country from an immigration or migration perspective, it's potentially going to be quite problematic the future.
Yeah, it's going to also increase cost significantly, right?
Yes.
That's the first thing. And also, I think, generally speaking, limits your ability to adapt to changes in the competitive environment and the markets and such. So, and also, implementing, for example, you see with the platforms, the initial response is a little bit of a panic and trying to regulate and dim, which is of course also an understandable response. But if you take a more of a bird's eye view, I think it's important to also think what are we actually trying to prevent here, right? So especially with the V-bar, this is more. If I would be able to, send a Christmas wish, in that sense, I would say I think we would be well or better off aiming at a basic safety net for workers that is universal, regardless of the nature of their work status, their contract status. And on top of that, leave the flexibility for the market to make use of to remain at a competitive edge or position, as you would say.
I think that's an excellent summary and analysis, Lucas. Thank you. Pete, I cannot see any questions coming in, but I think that's just the way I've got my screen set up. Is there any additional questions, Pete, that has come through?
Not that I'm aware of, Connor. There's
Okay.
nothing in the Q&A at the moment, but we still have that functionality open to our audience.
Wonderful. So hopefully that means Lucas has done an amazing job. I think you have, Lucas. You've really set the scene for what's coming up over the next 3 years in Netherlands, and also some of the main topics and items that end users and large companies need to be aware of. So just a huge thank you to you, Lucas. It's always a pleasure listening to you, but certainly working with you as well. Really appreciate you making the time to share your expertise and experience and some guidance on this topic, but crucially not binding legal advice. And also thanks so much to our clients, partners, and customers that have attended the forum today. Really appreciate it, guys. And we'll be following up with some information from today and some checklists that might be beneficial to you and your organization. So Lucas, thanks again. Really appreciate it. Pete, thank you very much for all the background work as ever. And thanks so much to everyone that joined today. Really appreciate it, guys, and hope to see you soon at our next in-person meeting. Thank you, everyone.